There's so much to talk about today, so let's dive right in, and I'm going to start with you, Gary. So some of you on the call today may have missed in the fog of the election last week that the US Supreme Court heard a major LGBTQ rights case the day after the election. So for those who were up all night, were able to wake up, the arguments were at 10 a.m. the next day. That case is Fulton versus City of Philadelphia, and it was brought by Catholic Social Services, or CSS, which had a contract with the city to provide foster care placement services. Philadelphia terminated that contract because CSS refused to comply with the city's non-discrimination requirements and work with same-sex foster parents. CSS is challenging the termination on the contract on federal grounds. So, Gary, you were listening to the arguments the day after the election. Thank you. Obviously, we have a newly comprised US Supreme Court. What were your takeaways?
Thanks, Janson, and welcome everyone. It's a little hard for me to figure out how to categorize this. So let me just, I try to put it in a few little boxes. So first of all, this should have been an easy case. Here is the government acting as a contractor, taking services and asking someone else to provide them. Services that they could have provided on their own. Philadelphia could have done this certification process for foster parents, and no one doubts that if they did that, they could apply this non-discrimination ordinance when they're doing that work. So if the government is a contractor as opposed to the sovereign, they get a lot more leeway. And there's also the question of what would the consequences be of ruling broadly in favor of CSS? It would mean that every contractor doing any government work would be able to raise religious objections. It potentially would mean that every government employee could raise religious objections to carrying out their work. And I think actually the court sees this. So, should have been an easy case, but it's not. And particularly with the death of Justice Ginsburg and the numbers on the Supreme Court, it is not. And why is that? And I suppose you all probably understand that, but Justices Alito and Kavanaugh kind of made it clear by using time at the oral argument to talk about the facts as they see them. And that is, they emphasize many times throughout the argument, Catholic Social Service has been doing this work for 2 centuries. It's an essential part of their ministry. They have served so many families and so many foster children. And then the question on the facts is, have any same-sex couples ever been turned away by Catholic Social Services? Well, they say no. And how many kids have been served by Catholic Social Services? And how many kids are waiting foster care services that Catholic Social Services can provide? And how many agencies are there in Philadelphia that do provide these services? And the answer is about 30 of them. And would they take referrals from Catholic Social Services of same-sex couples? Well, certainly they would. And certainly Catholic Social Services would make those referrals. And in that factual world as they perceive it, and all of those things are true. They may not be a complete picture, but they're true. And then Justice Breyer said at one point in the argument, so if CSS wins, that's crazy. But if the city wins, boy, that's really draconian. And so you can see where a justice that is normally sympathetic to LGBT rights, how he's looking at this picture. And then Justice Kavanaugh, who many people think is now going to be the new fulcrum on which decisions may rest, he says, well, we have 2 important rights at stake here. We have religious liberty and we have marriage equality. And we have to find a way to find a win-win solution to this. We have to be very careful. But then he says, but didn't the city pick this fight? Didn't they create this conflict? So we know he has maybe a view as to which side of that balance of those two rights is being harmed here. So what are they going to do, given all of that? And first, as you know, I hope from listening to us over the years that it's crazy to try to predict what the Supreme Court will do in any case. But the betting right now is that the court is going to find a narrow way to provide a win for Catholic social services. What might that result be? It could be 6-3, but I would say we ought to be prepared potentially even for an 8-1 win for Catholic social services. And I'd say that because Justice Kagan and Justice Breyer have both on religion issues been open to compromise and open to more protection for religious liberty in the country. And I think possibly voting in those ways in an effort to make the decisions as narrow and as acceptable as possible. And so that is what we could see here. And then the question is, how are they going to do it? Well, another thing I would say is why are they going to avoid a big, broad decision in favor of Catholic social services? And I think it's because of the consequences that I mentioned earlier about this. They could potentially be opening the door to allowing every government contractor and every government employee to raise religious objections to performing their job or performing the contract. And I honestly think none of them really, well, most of them do not want to go there. And so there was a lot of discussion at the argument about race, because clearly, and Justice Barrett, new Justice Barrett raised this question, well, what if the agency was excluding interracial couples? And that's clearly a consequence of an incredibly broad ruling in this case. So everybody on the other side tried to dance around that and essentially say, well, race is different. But justices across the spectrum kept coming back and saying, well, so you're telling us that it would never work with race, but what about gender? And what about sexual orientation? Are they going to get a different standard? And I didn't hear anybody who spoke on that subject suggest that they were willing to go there. So I think that's a factor that's in play here. So what are they going to do? What can they do? And if you all remember Masterpiece Cake from a few years ago, if you are asserting a free exercise violation, you don't really get anywhere if the law that you're challenging is neutral and generally applicable. And what that boils down to in ordinary common day terms is, does the law provide a lot of exceptions or exemptions, but doesn't give religious exemptions? And is there hostility expressed towards religion? And of course, we saw hostility was the angle that won the baker in Masterpiece Cake. Here, there's a lot of emphasis on exemptions because there is complexity in the foster care system about when they consider race in placement of children, when they consider disability. And so, for example, the Solicitor General had one take on this case, and that was there are millions of exemptions and therefore this has to fall. And there was tons of hostility expressed towards Catholic social services. They wouldn't budge outside that lane. And where the kind of hostility piece didn't get much attention last week, the exemption piece did get a lot of attention, and they may go in that direction. Another thing that came up is because I think they understand that this whole government as contractor is a problem, there was a lot of discussion about, well, maybe this is a licensing program and not a contract. Because if it's a license, then the government is not acting as a contractor, it's acting as the sovereign, and therefore is more constrained. And so it's possible that they're going to find a way to put Catholic social services in a different box to constrain the decision. So I think that's kind of what we're going to see. And then lastly on Fulton, let me say, we did see new Justice Amy Coney Barrett in play, and she asked some very interesting questions. She didn't tip her hand in any particular way, and she asked some hard questions of Catholic Social Services and the government supporting them. So, I mean, I don't think, I wouldn't expect anything from her that was going to support the city in this, but she did not reveal any hostility. For example, Justice Alito was incredibly hostile. And like I said, Justice Kavanaugh certainly tipped his hand a little bit about saying that the city had picked a fight here. So Janson, that's kind of the lay of the land on Fulton, I think. There's a lot more going on there, but that's a little bit of a brush of it.
I had this initial reaction when you were talking about how CSS said, of course, we would refer anything that's foster parents to another agency. And my first thought was like, how long is it until they start to argue that that's would be complicity with something that violates their religious beliefs, as they have made those arguments in the insurance coverage of contraceptive cases. So we will see.
Can I say one more thing about that? Because I do think a lot of people think, well, if there are referrals, why isn't that okay then? Why should we be pushing this issue? And I think the ACLU, who was an intervener in the case, had a very interesting point that they made to the court was, say a city just had 6 public swimming pools, and they decided not to run them themselves anymore, but to contract out the running of those pools. And one of those contractors said, well, sorry, but only white people can use this pool. Would it be okay? Would that be okay because there's 5 other pools and they would refer them to one of those other pools? And the answer is obviously not, right? There isn't any doubt about the answer to that question. And there's no doubt what the Supreme Court would say about that. And so is it any better that one of those pools says, well, we don't allow same-sex couples and their children in here? You know, that can't be right. So the referral question is much more complicated than it sometimes seems on face.
Yeah, and then of course, you know, beyond the dignitary harm or the stigma that you talk about, Gary, there's parts of the country where no, there aren't that many other social service agencies that would do those placements if, you know, they were allowed out of that obligation. Before we move on to the next case, which is the ACA case that was argued yesterday, Gary, could you just really quickly talk about what GLAAD's role and contribution in the Fulton case was? The case obviously was defended by the city of Philadelphia, who were the defendants, and then the ACLU intervened. But GLAAD certainly was, you know, part of the, you know, strategy team as well too. Is that right?
Yes, yes. We were part of the amicus strategy in the case, and we also were drafters of what I thought was a very nice brief. I talked about it. It's take too much time to talk about it, but we did a brief just about all of the advances that have been made in terms of LGBT people in the country under our laws, and how this would be an incredible setback if there was a broad victory for Catholic social services, while also acknowledging that religious liberty is an important value in our Constitution.
So moving on to just yesterday, another blockbuster case was argued about the constitutionality of the individual mandate of the Affordable Care Act, or Obamacare. It has the potential of bringing down the ACA in its entirety, which would hurt so many LGBTQ people, especially transgender people and people living with HIV. After listening to the arguments yesterday, do we need to be worried about the future of the ACA, Gary?
Well, after I just said that it's crazy to predict the result of a Supreme Court decision, there are a lot of people predicting the answer to this case and saying the ACA will not fall. And that does seem to be a reasonable prediction of what is going to happen. This was about as close to a legal Hail Mary by the opponents of the ACA as I suppose you can imagine. And they have 3 significant hurdles to overcome. Just as a technical matter, you all probably have heard of the notion of standing. to bring a lawsuit in federal court, you have to have a personal case or controversy where you allege an injury that can be cured by the action the court could take. And here, there are real questions about whether the states that have sued have any injury they can allege as a result of the mandate, which is their focus of their attack. They have a very clever, but maybe too clever argument that they have standing by inseverability, which means that even though they're challenging the mandate, they can say they're harmed under other provisions of the ACA that they're not challenging. That goes against settled Supreme Court precedent. So it's a heavy lift. No one is clear how the court's going to view that question. If they get past that question, then they're arguing that the individual mandate is unconstitutional. Now, the individual mandate survived in 2012, thanks to Chief Justice Roberts. And, but now they're saying, well, Congress repealed the mandate. And so therefore, or repealed the tax, but left the mandate in place. And since there's no tax penalty, this mandate is a pure command, and that command is unconstitutional. Well, I think Justice Kagan, who often gets to the core of the issue very succinctly, said to the government, well, so when there was a penalty in place, you had a choice: buy insurance or pay the penalty. And we said that wasn't a command that was unconstitutional. Now Congress has taken away the penalty. So the choice is buy insurance or don't buy insurance. How is that more coercive than what we said was constitutional 8 years ago? There's no answer to that question, but we'll see what they do. So assuming they get over the second hurdle, that the mandate is unconstitutional, then they have to argue that the whole law must fall because the mandate falls. And that's what the court talks about in terms of what they call severability. If a provision of a statute is unconstitutional, does the whole edifice fall, or can it be severed from the law and the law goes forward? Okay, so the challengers are saying, oh, the whole law has to fall. And they have an argument based upon the fact that back in 2012, the Obama administration, the same lawyer, Don Verrilli, stood before the court and said, this law can't survive without the mandate. It's necessary because otherwise the market for insurance will collapse. And so that's what is getting thrown back at Verrilli and the people supporting the ACA yesterday. But the bottom line is, when the court looks at this severability question, the first thing is their presumption is to preserve the law. Their second, they look at, well, what would Congress have wanted? And Chief Justice Roberts said it. Well, they repealed the tax and left the statute. Doesn't that tell us exactly what they wanted? And then he said in a quip aside, yeah, they wanted us to throw the law out, and that's not our job. So Justice Kavanaugh also said, well, under our clear law on severability, where he wrote an important decision just about 4 months ago, this law stands. So people are reading Chief Justice Roberts and Kavanaugh as having said clear as a bell, they don't think this law is inseverable, and therefore take out the mandate, even if it is unconstitutional, the rest of the law survives. So that's why people are feeling pretty comfortable in predicting a win, even if the court gets to the third question. Hopefully that made some sense.
Well, certainly there's a lot at stake here, but I'm glad to hear, knock on wood, that things look favorable for the ACA. And it also seems clear that, the U.S. Supreme Court certainly is a much, different calculus these days going forward than it was before RBG's death. What else are you looking at, Gary, that might, related to the U.S. Supreme Court? And, what should we be concerned about? And also I see a question from Ali here about, going back to the CSS case, what would a narrow victory or for CSS or a narrow loss from us look like? Because it certainly seems as if one of our strategies currently and going forward, is how to limit the damage of any losses as much as possible.
Okay, well, let me just say in terms of there is potentially a lot going on at the Supreme Court. There have been some reasonably good things recently. In a case called Edmo versus Idaho, the Supreme Court turned down a case, an Eighth Amendment case by a prisoner seeking who got gender confirmation surgery. And Idaho took that to the Supreme Court. The Supreme Court denied review. And we had a little dissent from Alito and Thomas saying that, and what they would have said was that the case was moot because the surgery had happened. But their point in saying that is, if the Supreme Court renders a case moot, it vacates the decision below. And they would have liked to have wiped out the Ninth Circuit's opinion affirming Edmo's right to this surgery as an Eighth Amendment right. And they didn't get that, the two of them. So that was a good thing. You probably saw that Kim Davis, the clerk in Kentucky, lost her appeal to the Supreme Court about denying marriage licenses to same-sex couples. I mean, again, that sent some reverberations around because this time Thomas, writing joined by Alito, said that they were upset about how Obergefell created this right without protecting people who had religious objections. And so he said that this case raised important questions about the scope of our decision in Obergefell, but that the circumstances weren't right to grant review. So a lot of people took this as an invitation to bring the court cases about Obergefell and its vitality. We've talked about this internally, and this conversation is going on around the country. Obergefell, I think, my personal opinion, Obergefell is safe. It's going to be hard to raise a direct challenge to it. Could it happen? Yes, it could happen. Is it vulnerable? I personally don't think so, but it's certainly something that we have to keep our eye on. But will there be issues around the rights associated with marriage? I think so. One of those cases is at the Supreme Court right now. That's the Henderson case out of Indiana, which talks about birth certificates. And in that case, Indiana did not want to put the wife of the birth mother's name on the birth certificate. You would have thought that issue was resolved in the Pavon case from the Supreme Court out of Arkansas, which said that, yes, you have to put the names of same-sex married spouses on birth certificates. But Indiana has a slightly different argument in this case about their system, and they still want a biology-based birth certificate system. The Seventh Circuit disagreed with Indiana, with two of the three judges being really, really conservative judges who disagreed and ruled in favor of the parents. But that case is at the Supreme Court. It is, when you file a petition for cert, as Indiana did here, if you're on the other side, you don't have to file a response. You can say, we're waiving our right to file a response. It's sometimes a way of conveying to the court that you think the other side has a frivolous appeal. The court asked for a response, which one justice can do, and that response was due yesterday. So the case will get teed up now for going to a conference of the justices, and we'll see where that goes. I wouldn't put my money on that case being granted. Arlene's Flowers, which is another case like Masterpiece Cake that's been up to the court and back and is now up to the court again, is being held waiting for the result in Fulton. There is another case out of California about a Catholic hospital refusing to provide a hysterectomy to a transgender patient, where they provide hysterectomies to non-transgender patients. That case is at the court. It was sent to conference at the end of September and nothing has happened, which I think means it's also going to be held for Fulton, but we don't know that for sure. Cases that might get there are two cases out of federal circuit courts that deal with the question of transgender students being allowed access to the appropriate bathroom In both of those cases, the student won. One is Gavin Grimm, which you may have heard about. Another is called the Adams case out of Florida. And those two cases could well be petitions to the Supreme Court soon. In the Gavin Grimm case, which has been to the court once, Gavin won again. It went to what they call a request for an en banc hearing by the entire Fourth Circuit Court of Appeals. That was denied. And one of the justices who was in dissent said, well, I agree, because there's no point having us look at it again. Why don't you go straight to the Supreme Court? So I'm assuming they will try again. And then lastly, or two more things, there are conversion therapy ban cases that are working their way through the federal courts. One of them was argued in the 11th Circuit in Atlanta in February, and there's no decision yet, but there could well be a cert petition out of that. And then lastly, there's a case called Devash Banks out of California in the 9th Circuit, and it is one of several cases now being litigated about citizenship. And this is a case involving when you have a child born outside the United States to parents, one of whom is a US citizen and one of whom is not, you can petition for citizenship for that child. In only what a law school exam could imagine, this is a case involving twins. And these twins were born to a gay male couple, married couple in Canada. One of the children is biologically related to the US citizen. One of them is related biologically to the Israeli citizen. The petition for citizenship for the twin related biologically to the US citizen was granted. The petition for the child related to the Israeli citizen was denied. And it raises a question under the US immigration laws, and the 9th Circuit has affirmed that both of them are entitled to be granted US citizenship. Whether that goes up to the US Supreme Court, we don't know. But because with the change in administrations, I think we would have thought for sure it was going up under a new Trump administration, but I doubt it will be pursued. But
got it.
So there we are. That's what I know at the moment.
Well, that's a lot to keep our eyes on, Gary. So thank you for being such a devotee of SCOTUS blog and staying up on all the latest. We're going to switch gears now and talk a little bit about the results of the election and what it means for our movement. So we now have clear, relieving results from the presidential election, and the Biden-Harris administration will be sworn in on January 20th. Control of the Senate, however, remains up in the air, and so it remains to be seen whether or not we will have a pro-equality majority there. Given the uncertainty on the Senate side, Jennifer, let's just focus on what can the Biden administration get done even without Congress? What are the federal agencies' priorities, LGBTQ priorities that we should be pressuring the Biden administration about? What can they do through executive orders, policy letters, guidance, regulations? So what should be our priorities be going ahead with the administration?
Yeah, Janson. Well, first, I just want to say thanks so much to Gary as well. The wisdom that he brings and the clarity in talking about these cases is just so important to all of us at GLAAD, but also to the community and to the movement. So I am just so appreciative and grateful to that. But yeah, Janson, gosh, there's so much to clean up given all that the Trump administration has done over the 4 years. And in terms of priorities, there are many, but kind of on top of mind, they include restoring protections for LGBTQ students. This is a huge priority. I think many people probably recall that one of the very first attacks by this administration on the LGBTQ community came from the Department of Education, which withdrew guidance that had been sent by the prior administration to schools across the country, advising on how to ensure full inclusion of LGBTQ students. But of course, that was just the start of what we saw from the Department of Education. And over the last 4 years, that hostility escalated to the point where most recently, the Department of Education, with the support of the Department of Justice has taken the position that affirmative inclusive policies for transgender students actually violates federal law. And on that interpretation, the federal government has lined up with right-wing groups that are suing to reverse transgender inclusive policies. And they've also threatened funding for schools that stand behind trans protective policies. So obviously that's hugely important, and reversing policies that have made young people even who are vulnerable even more so is really in our immediate sights. But the damage inflicted over 4 years has obviously been really broad and quite deep. And so other priorities include bringing back federal Bureau of Prison policies that had ensured appropriate placement of transgender people who are incarcerated. We also, of course, want to see reinstated the interpretation that had been issued by the Department of Health and Human Services, making clear that the Affordable Care Act's non-discrimination provision covers LGBTQ people. That's if the Affordable Care Act survives, but I think it will. But that interpretation had been, which was reversed by this administration, has been hugely important in making sure that people can fairly obtain healthcare, receive treatment at hospitals and medical centers. So of course, the HHS can't change what the Affordable Care Act itself says, but its release of a rule that purports to cut back on the scope of the law's protection has created a lot of confusion and put people in harm's way. We're also keeping a sharp eye out to see what the administration is going to do over the next, I think it's 69 days, because we are likely to see even more damage done in these final several weeks. We expect to have to work on reversing a rule that has yet to be finalized by Housing and Urban Development that authorizes homeless shelters to turn transgender people away. I mean, it's really just shocking, the brutality of this administration. We'll need to reverse a rule that's been jointly proposed by the Department of Justice and Department of Homeland Security that seeks to radically change the ability of victims of violence in their home countries to seek asylum. And this administration has effectively sought to basically end asylum, including for LGBTQ people and people with HIV/AIDS. I'll just say it's hard to anticipate all that we may see in the coming weeks. Just before the election, we saw this administration issue several executive orders trying to basically ban training necessary on around diversity and inclusion. So it's hard to predict how much more we may yet need to do.
Thank you, Jennifer, for that summary. Now, executive orders, policy letters, those seem relatively easy to reverse, but for those regulations that have been finalized, how quick and easy can those be overturned or reversed?
Yeah, so that's where a lot depends on whether we have a pro-equality majority in the Senate, because some of the damaging policies and agency rules passed during the Trump administration could, with the support of a pro-equality Congress, be undone quite easily because of something called the Congressional Review Act, which is very technical and complicated. But the CRA gives Congress expedited authority to pass new agency regulations and also to overturn recently adopted ones. But if there's not a commitment to LGBT equality in Congress, it will be more difficult to reverse policies that have been the result of formal agency action rather than by informal means. Things that have been done by agency guidance, like the Department of Education letter or presidential executive order, obviously are easier to undo, but changes that have come through formal rulemaking, agency rulemaking, will be harder. The takeaway here is that the change in the administration, presidential administration, is very significant, but our system does set up this system of checks and balances that makes it easier to make change where there's agreement across the branches of government and more difficult where there's not.
Thanks. And my last question. So Jennifer, you've obviously been litigating against the transgender military ban from almost the moment it was announced by tweet in 2017. It's involved multiple lawsuits, including a fourth lawsuit that GLAAD just filed last week. Can you tell us what a Biden administration would mean for the future of the ban?
A lot. So here's where hopefully there's a quick and easy fix to deal with the military ban. Obviously, it can't come soon enough for people who continue to face the possibility of discharge if they come out as transgender in the military, and obviously not soon enough for people who are not able to enlist right now. But President Biden, I'll say, can order the military to reverse the transgender military ban, and he had during the campaign pledged to do that on day one. So the reality is that the military is actually, I mean, this is so odd, but the military has retained two different tracks, and one bans all transgender people from enlisting and subjects anyone who has come out since April 2019 to discharge. But they've had to maintain a separate track that applies to this very small group of transgender people who were grandfathered in because they came out during the open service policy. And basically all the Biden administration has to do is to get rid of the discriminatory track. Glad's working in collaboration with partner and allied groups to really see that happens quickly, and I hope it does.
Well, that will be a huge victory, hopefully on day one. Glad's litigation has had such benefits, though, for the trans community. For one, it kept the ban from going into effect for a good 2 years, which really minimized a lot of harm to a lot of service members. But then also, it's just been an extraordinary public education vehicle as well, too. And we will continue to educate folks about the reality of transgender people's lives, even after the ban has been, reversed, which we hope happens very soon. So that brings us to the end of our time. Thank you all so much for joining. Again, thank you to our Equal Justice Council members who really make everything you just heard possible. You can visit our website at glad.org or follow us on Twitter, Facebook, or Instagram at GladLaw to learn more, to stay in touch. Feel free to reach out to any one of us in the development staff or myself if you have any follow-up questions from today. A reminder that you can contact gladanswers.org if you're experiencing discrimination in any context or need legal information or help, or please pass along that resource to those in your lives and community. There's a lot going on right now. There is still uncertainty, but we at GLAD not only have hope, but we are committed to stick in this fight and ensure that we see true justice for all at the end of this. So thank you so much for staying with us. Thank you for all of your support and all you do for our communities. Take care and have a wonderful rest of your afternoon.